Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up For You. Today is Tuesday, October 4th, 2022. I am Sonja Ebron, a co-founder at Courtroom 5.
And I am Debra Sloan, the other co-founder at Courtroom 5.
Got a marvelous show in line for you today. You know, we began our podcast a little over 3 weeks ago with something of an humble brag, if you will, about our ability to represent ourselves in court. And today we just want to remind everybody that we didn't get there the easy way. We learned how to represent ourselves from numerous experiences in court where we just really screwed up. And so just want to highlight some of the common errors that we made. We'll spend just a couple minutes on that. A little later in the show, we will speak with Otto Hanson at TermScout. TermScout is doing something about some good work in the kinds of contracts that we run into all the time when browsing the web, and they are trying to work on some solutions to that. So looking forward to that conversation. Before we get there, though, Deborah, what is on your mind today? What's the issue of the day?
Issue of the day, I've been just thinking about judgment forms. And in some courts, if you're pro se, or in many courts, if you're pro se and you lose a case, the attorney on the other side can send you something called a judgment form, which looks very much like a bank loan application form because it asks all the same kinds of questions. And I remember this because I lost a case, and immediately the attorney sent me one of these. I'm not sure it's called a judgment forms, but it was a form to complete to basically tell them where my money was, where my assets are. And I plan to appeal the case. I appealed the case and I won, but I just remember how uh, I just remember the outrage I had of being asked to give all of my personal information to this person, and I really felt that he should not have gotten that victory. And it turns out that the appellate court agreed with me.
I remember that there was no victory. You either didn't fill it out, didn't submit, didn't respond to that request, or wrote "not applicable" all over the form and submitted that. I don't think you handed over any personal information to help him collect what turned out not to be a judgment. In fact, it's a good warning to other people. I don't, you don't always have to respond to something that your opposing counsel might send you. Sometimes you do, and there are consequences when you don't. So you want to know, what the
Mhm.
rules are there, but you don't always have to, and shouldn't feel bullied in those circumstances. As you said, you had that judgment overturned, and would have never had to turn over any information that helped anybody collect any judgment. So yeah, it's just a good warning. I don't know why courts can't wait or somehow restrict the sending of those collection documents or requests for your assets after giving a judgment. There is a period of time where the losing party has the right to appeal. It's not a significantly long time, 30 days or so. There's no reason to rush to collect anything before that period of time. So there's a lot that courts can do to protect people that apparently they don't. But that's a good
Absolutely.
reminder. Well, who wrote that up for you is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. And so if you are in court without a lawyer, or you need to sue someone and can't afford a lawyer to represent you, get yourself over to courtroom5.com, try a limited version of our services for free and see if we can provide some relief for you in that situation. Deborah, I want to chat about some of the times we have screwed up in court. There's this particular case I'm thinking in particular where our landlord had tried for years to evict us wrongly. She had no grounds. We were doing what we were supposed to as tenants, and she just didn't like us. And we had defeated her in the past, and this time she brought an army, property management company she'd hired, and a lawyer for them who was a previous judge, and just all kinds of folks to get us out of her house, as I recall her saying. One time, and she actually beat us in eviction court this particular time. We had the means to appeal that and got that decision reversed in a real court, right? But along the way, as you recall, we found that cabal, property management company and folks, had illegally evicted about 400 people in the years before they got to us. And we thought that was horrible and wanted to stop it. And we had some facility with the law. We thought we were pretty smart and handy at that point, having reversed an eviction judgment. We filed a RICO complaint, all right, against these people because, in fact, they had committed perjury on every complaint, every eviction complaint that they had filed, which they had to do under oath. And so we put together, we knew our elements, and we put together this great fancy complaint, and we sued these people just to get them to stop doing what they were continuing to do. And it was a beautiful thing, we thought, because hell, all the evidence was in the clerk of court's office, right there in the courthouse, right? Um, anyway, we screwed that up so badly. I mean, we made all kinds of mistakes.
Yeah, coming off that eviction case, boy, we thought we were bad, and so we we filed we sued them, and we moved quickly for summary judgment. And this summary judgment motion was beautiful. We had all the facts, we had all the law. I mean, it was wonderful, wonderful, wonderful. And we just thought, I mean, it was right there in the clerk's office, everything that we needed, all the evidence. One thing that was missing, there was no citation to the record anywhere in that summary judgment motion. We didn't know we had to do that. And we just thought we had an airtight case. And missing that procedural point, missing that procedural step caused us basically to lose on this particular motion.
I remember we actually showed the complaint to a friend of a friend who was a judge in a different state, and she was like, "Wow, this is extraordinary." And she said, "Yeah, you got all the elements. It looks like, but let me just suggest you go get yourself a lawyer to prosecute this claim." Because you're liable to get your butt kicked in a real court. And I so wish we had taken that advice or been able to, take that advice. But what else did we do? I think we screwed
And
up in a number of ways.
yeah, and she didn't tell us what was wrong, but she probably knew immediately. So the second blunder in the same case is the defendants filed a motion to dismiss, and it looked ridiculous because what they were alleging is that what we that our complaint, the elements of our complaint were the elements of some other claim. And we and we thought that was just ridiculous because we knew that we had all the elements. We moved for Rico, and we had all the elements. All the elements were there, and all the facts, they were all there. We had evidence for everything, and they said, "No, you're not complaining about that. You're complaining about this other thing." And we were like, "Oh, that's so stupid." And so we we were expecting the judge to see that this motion was just ridiculous. And so we didn't respond properly.
I
And
remember.
eventually we that not responding properly made us lose on that motion to dismiss.
Yeah, I remember. I remember arguing on that in response to that motion that some analogies about. Oh, I don't even remember what it was, but it wasn't a legal. It was not a legal argument. It was like, come on, judge, you see how stupid this is, right? You know, it's like this other example. You know, it was pretty bad looking back on it, and and honestly, I mean, and so the judge granted the motion to dismiss because we did not have a proper response. It was really, really shocking, I think, for us that the judge couldn't see what we saw. This was just frivolous. I mean, the guy should have been sanctioned for putting up such a ridiculous motion to dismiss, and it was really difficult and painful for a while. And on reflection, though, and I remember watching this judge and the rest of his career. He's since retired, but was a pretty fair guy generally, fairly good judge. I think what he saw is that we had submitted just an incredibly stupid summary judgment motion that didn't even deserve a hearing, and in fact didn't get a hearing, right? And that we were simply poised to waste the court's time. As pro se litigants. And so he took the opportunity of our failure to respond properly on that motion to dismiss the case and get us out of his court, so he could make better use of the court's resources there. Can't blame him very much there. What else
Yeah,
did we do?
looking at that in retrospect, but at the time we were hot.
Oh, it
But
was painful.
anyway,
It was painful.
and finally, we once the judge dismissed the case, we filed a motion for reconsideration without any new facts or law. We basically said, "Come on now, judge.
You
You
know,
know that you know that was stupid. Come on now." That's basically what we said in the motion for reconsideration. There was nothing new that's required. It's required that you at least have something new or something that the judge overlooked, and we didn't have any of that.
that was the requirement, but we actually did better than that, as I recall. We made the argument just in meticulous fashion that not only had we supported the elements of the claim we'd propounded, that RICO complaint, with facts. We had facts to support all the elements of that. We made that argument, but then secondly, we also argued that the other claim, I think it was abusive litigation or some nonsense, um, that other claim we had not pled facts to support, right? And so,
Exactly.
yeah, that claim would not have been viable. And I thought, had we made that argument, in response to the motion, but not on reconsideration, then we might have got a different outcome. Might have got a different outcome there, but the judge on reconsideration, unless you bring up some new law or some new facts, right, that hadn't been considered earlier. Judge doesn't
Just-
have to do anything on a motion for reconsideration, and didn't even respond to it. Right, just went on Christmas break, and the case was dismissed. So yeah,
I don't even think we said it for a hearing though. We didn't know that stuff at that
yeah,
time.
that's right. That's right. You won't get an outcome generally in state court if you don't set a motion for hearing, and we weren't sophisticated enough to know that at the time. So yeah, lots of mistakes. Like I said, we maybe do a little bit better in more recent cases. I won't. I won't talk about anything pending, but I think we have proven ourselves more recently. But this ability to do that capably, and certainly to help other people avoid these types of blunders, comes from making a lot of blunders of our own.
Exactly.
And so it's just important to recognize that. Fantastic. Deborah, who won yesterday's quiz, and what do you have teed up for us today?
Okay, yesterday was fairly easy, I think. Um, yesterday's quiz was a motion is, and the answer is a request to a court for an order. The other three suggested answers are not quite on point. And so the winner is Cheryl P.
Congratulations
Congratulations.
to Cheryl there.
And today's quiz: Greta lost her appeal of a debt collection case because she did not preserve the errors complained of. What does that mean? What does it mean when an appellate court says that the errors were not preserved for appeal? If you want to participate in the quiz, send your responses to quiz@courtroom5.com.
Great. Fantastic. Looking forward to seeing the answers there. And for anybody terrified about these questions, I I don't see them as easy either. So they're going to take some work there. But hopefully we'll get a good response there and a good winner. At this time, I'd like to welcome onto the show Otto Hanson at TermScout. Otto, how are you?
Hey, Sonja. Hey, Debra. I'm really well. Thank you for having me. It's wonderful to see you.
Great to see you
Hey,
always. And Otto, we introduced you as the CEO and founder of TermScout. You all are doing some interesting work there to try to give web browsers and consumers in general the capability to deal with all of these agreements and terms that we just automatically click to accept as we're browsing the web. The work you're doing, frankly, terrifies me because if I don't think about the way I'm clicking as I'm moving through the web, you can't be afraid of what you don't know, right? But you make me know. The work you all are doing make me aware of just the dangers I am getting into as I'm clicking, through the web. And people, this, web browsers have about that much attention span. Very few of us, right, are going to stop and what's all this legalese that they're asking me to just accept? Anytime you buy some software from one of the big software makers online, you got to scroll. These things make you scroll to get to the bottom and click to
That's
accept.
right.
I don't know anybody who's ever read any of that stuff. And so, yeah, tell me, just how did you get concerned about this problem and decide to do something about it?
Oh, great question, Sonja. So I was practicing law at a law firm, and a client of mine was running one of those companies where they had a contract that they had their users click accept to. And the client came to me and he said, Otto, I want you to make our contract as aggressive as humanly possible. And I said, geez, why would we want to do that? And he said, well, we just found out that our customers, like you just said, they never read the contract. They're just clicking accept. They're not even looking at it. If everybody's just going to agree to our terms without looking at them, why wouldn't we make this contract such that we win and you lose? It's a great opportunity. It's a great business rationale. And it crushed me because I looked up and I looked at all the contracts that are like that. We call them one-to-many contracts, a contract where I draft it once and hundreds, thousands, maybe millions or billions of people are going to go sign it. And I have all the power in that relationship. There's this huge power disparity, right? Where I can dictate those terms. And each of you are just such a small piece of my business that if you tried to negotiate, come on, you just don't have enough power as an individual to actually influence those terms. And it to me felt like a huge broken system. When you have that sort of information asymmetry, it creates opportunism, right? It creates an incentive for those who have that power to exploit it. It's natural, it's human nature. And so we looked at that, my co-founders and I, and he said, I think there's actually a really great easy fix to this problem, which is transparency in contracts. If actually there was a way to look at those contracts, if you and I and each of us could go look at this client of mine's contract, and there was a neutral third party that said, whoa, everybody, this one's really bad, and everybody aligned around that, well, that creates an incentive for that company. That's the answer I needed when I was representing that company to say, actually, what are you going to do when TermScout reads that and tells the whole world, this is a really bad contract. This is an entrepreneur who wanted to take advantage of his customers.
Wow. Wow. That's fantastic. And so tell me then how TermScout is addressing this problem. What's the solution here?
So what we do is we analyze contracts in a standardized way. We answer what we think are every question that matters in that contract. Is there a non-compete in this thing? Am I giving up my rights to sue you if something goes wrong? And so on and so forth. We answer hundreds of questions in every contract. And then we compare those questions, those answers, across different contracts. We developed a rating algorithm on top of that. So you can go up onto termscout.com and pull up, for example. Now, one caveat, we work in contract type. So today we haven't actually done like a lot of consumer stuff like Facebook or Instagram and the like, but we have done a lot of contracts that small businesses use, Salesforce, Microsoft, HubSpot, you name it, YouTube, Google. And you can go in and find out which of these contracts are actually reasonable. A lot of those companies, by the way, are going out of their way to make sure that their contracts are fair. They're taking a very fair and balanced approach to their contracts. And a lot of companies out there are not. And TermScout's platform for free will help you figure out which of the businesses that I'm engaging with are reasonable and which ones are not. And the hope is that we'll level the playing field a little bit.
So as a consumer, then this is a fantastic opportunity for me to at least think through some of the contracts that I'm entering into as I'm browsing the web here, right? How does it work for me as a consumer? I go to TermScout, or are you on these specific websites that I'm browsing?
So today you go to TermScout. We are on some websites. Look, when there's a contract that's really good, like take IBM, for example, they have a really great customer contract and they'll actually, you can go on their contract and they've got a badge up there that says, hey, TermScout has reviewed this and they've certified it as customer friendly. So we hope to see more and more of that as we grow as a company. But for now, most of the time, you actually have to come to our site to learn about different companies' contracts. And you can go in and click sign up in the top right and create a free account and go looking for contracts that you want. We're actually launching in Q4. So in the next few months, we're launching an AI-only product that will enable users to go and upload any contract. So they could go take the Facebook terms of use and upload it, and we'll give them a prediction of our results based on the AI output. So look, it'll take time for that to get perfect, but it should be a great way to start to get some really good analytics on contracts, even ones that we haven't already reviewed. The corpus of contracts that we've already reviewed have gone through a human quality control process to make sure that the data is really, really accurate. So, if you go look up the Microsoft contract or the Salesforce contract that I mentioned earlier, that's gone through a robust quality control process. We're very, very confident in the data that we've published on those contracts. The AI only tool would not go through that process, but it would give you instant and very affordable results on any contract.
That's excellent. That is excellent. And you said very affordable. Give us a range, or like what would I as a consumer, is it per contract? Is it per, how do I pay for this service?
To be honest, Sonia, we haven't figured out the pricing model yet on the AI only product. This will be our first launch of an AI only product.
Yeah.
And it's more calibrated for small businesses. That's most of the contracts that we review are kind of business contracts today. Yeah. Our long-term vision is to branch into all contracts. And like when I think about what consumers need the most, it's, to me, the big ticket expenses. It's the big ticket things, the leases. I'm going to rent a house for 12 months. It's a lot that could go wrong. The AC breaks. Who's paying for that? The heater goes down in the middle of winter. Is that on you or me? Stuff like that really matters. Our long-term vision for us as a company is to get more and more into consumer types of contracts, but we've got a long way to go before we're really a great consumer-facing company.
That's extraordinary. I'm going to want to watch your progress, and you know that I am. Let me ask though, as a consumer or even as a small business owner, as I'm going through and click accepting all of these contracts, like what's the danger for me? What kind of trouble can I get in? I get the AC going out and who's going to pay. I get that danger. That's very concrete. But as I'm browsing the web and giving up my rights every click, right? What are some of the dangers there that you want to address long term?
Yeah, good question. So when it comes to just the day in and day out stuff that we're using on the web, I think the risks fall into just a couple of buckets. One, privacy. And some people care more and less about this, but we all know, right? We're all educated consumers at this point. We know that when we go and use Facebook, we're kind of making a deal with them that they're going to have access to our data to serve us up ads and everything else. So There's a lot of data stuff in there. Can they follow me around to other websites that I'm going to? What can they do with my data? Who can they sell it to? So on and so forth. So data is one big bucket of gnarly, hairy, interesting stuff. I think the second big important bucket of just run-of-the-mill internet services is remedies. And you guys know all about this even better than me, but what happens when something goes wrong with one of these companies? What happens if Facebook or whatever company violates the contract that they made with me? And what are my remedies? And many of these online click accept terms actually ask the user to give up their constitutional rights to a remedy. So you go in and you say, oh, under the Constitution, I should be entitled to go seek justice, sue you, and make myself whole. Well, you go in, you look at the contract that you signed, and oftentimes it actually says in there, no, I gave that right up. And that's one of the things. Now, there are some laws, I think, out there that are addressing that are trying to ratchet that back a little bit. Sometimes companies get around it by saying, oh, yeah, you can sue us, but the max you can ever recover is $100. I'm sorry, but it ain't worth anybody's time to go through the process, the justice system for $100,
Right.
and you're giving up your rights to class action lawsuits as well. So, to me, those are the two big buckets of things that are really interesting. Now, when you get into specific industries, there's more. You get into airlines, for example. What happens when you lose my bag? Okay, we can compare that across different airlines and see who's taking the best care of their passengers. You get into rental cars, who's got the best insurance policies. So, it gets sticky. And that's part of why what we're doing is so hard, is because it's not as simple as just saying all contracts are the same. They're not. They vary, and the variations matter a lot when you get into the difference between an airline contract and a Facebook and a rental car and a lease,
Yeah. And you're right. I mean, it's got to be very hard when you look at the variety of contracts and all the terms out there. I think that's also, though, why what you're doing is so valuable. So Godspeed on that. We need a service like that, because I still, knowing the dangers, I don't stop and read the terms. That's just not going to happen in web browsing. So really important
I hear you.
To have that service. Really appreciate it. Otto, I'm going to post your website here on the screen, but where else can folks find you online?
Oh, thanks for doing that, Debra. Sonja, LinkedIn is, we're most active on LinkedIn. We post a lot of data about commonly signed contracts there. That's probably the next best place.
Fantastic. We'll make sure that's in the run of show so folks can reach out. Otto, thank you so much for coming on. Who wrote that up for you? We'll have you back. We're going to continue to watch your progress and look for the day when I can get a little bit more protection as a consumer on the web. Thank you so much for joining us.
Thanks, Otto.
Thank you, ladies. Thanks for having me. Bye.
So important to have these sorts of services and this kind of work being done. There's so much danger for us as consumers, whether we're in court or not, just out here browsing the web. So glad to be able to share the work that Otto and his team at TermScout are doing there.
Yeah, it's like opening up a can of worms, because you're actually making people think now, and I'm not sure that's what they want to do, but it would be good to know the essentials of what you're signing, see what you're signing away, and so I really like that he's on that, on top of that.
Absolutely. That's all we've got for you today. As always, we will see you on tomorrow. Thanks everybody for joining us.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.